Hi, good afternoon. For those who join us here, both in person and online, and welcome to the workshop sessions Applying International Law Principle in the Digital Space. So my name is Sanhawan Sisot, and I'm Senior Legal Advisor at the International Commission of Jurists, and I'm going to moderate the session today. So let me begin with the purpose of today's sessions. So the title is Applying International Law Principle in the Digital Space. And what we're going to discuss today is we're going to explore how existing international law provide a regulatory framework to protect individuals and communities from human rights abuse in the digital space. And we also going to discuss about how different bodies of law interact in this increasingly complex digital world. We also touch upon some state obligation, corporate responsibility, and involving directions of accountability for both state and corporate actors under international law, and also discuss about recent developments and remaining gaps as well. So this discussion is also part of a broader project co-implemented by International Commission of Jurists and the Danish Institute for Human Rights, who's our co-partner today under the Digital Democracy Initiatives. So under this initiative, with a group of experts, whom several of them is also from part of the panelists today, we draft a set of principles which seek to clarify how international law should be progressively interpreted and to address some ambiguity and contradiction if there ever exists. So as for the format of the sessions, I think we will spend the first 25 to 50 minutes for presentation by panelists, and then another 25 minutes for Q&A, comments in the interactive dialogue with participants, and we'll conclude the sessions with brief wrap-up remarks from panelists. So let me begin with like a brief introduction of the panelists today. Before introducing all the panelists, I would like to acknowledge that indeed we originally have panelists with us, which is Nadim Nashif, the founder and director of Hamle, which is a Palestinian digital rights group. He was originally on the list of the panelists, but he unfortunately unable to travel today due to the ongoing war between Israel and Iran. However, we have his colleague with us today, Tessia Makroufi. She's an EU advocacy officer of Hamle. Another panelist who joined us from online is Francisco Brito Cruz. He's a law professor at Fundação Getúlio Vargas in Brazil, also executive director of Internet Lab and consultant at OHR BTech projects. Another panelist with us here in the room is Chantal Joris. She's a senior legal advisor at Article 19. And next to her here is Neves Molina Cromong, Chief Advisor of the Tech, Business and Human Rights at the Danish Institute for Human Rights. And last, that side is Mikiko Otani, the former chair of the UN Committee on the Rights of the Child and also ICJ Commissioner. So let's begin the discussions. So for the first issues, I would like to begin with Chantal. Probably you can, if we talk about the topic we are discussing today, which is on international law in the digital space. So of course, this topic begins with the concept that international law offline apply online. Like there's a certain kind of consensus on this. But in the reality, when we talk about international law, people will ask like which one we are talking about. Are you talking about international human rights law? Are you talking about international humanitarian law? Are you talking about international criminal law? Are you talking about everything, or are you talking about the framework on corporate? So probably you can help us set the scene how this framework interact, or are they even interact with each other? Are there any some harmonization between all the so-called international law, this patchwork of international law or not? Or if there's any gaps that exist or remain? The floor is yours.
Thank you very much, and thanks everyone for joining us. Yeah, as you said, there is broad consensus that international law applies to cyberspace, and that cyberspace is not a lawless space. But What that means in practice is still very much a subject to discussion and to controversial discussions. For example, to what extent cyber conduct might constitute an illegal use of force or a violation of the prohibition of the principle of non-intervention. And these questions are being discussed within different initiatives under international humanitarian law. For example, the ICRC has been working extensively on understanding how those norms that have been established, in particular the binding rules that have been established many decades ago, how these norms can still be interpreted in a manner that they continue to be relevant in cyberspace. I would say international human rights law has probably the most advanced understanding, I would say, about how it applies. As you mentioned, the same rights are understood to apply offline as much as they apply online. There are extensive reports, for example, by mandate holders, by the Human Rights Committee, to explain what it means, for example, to be able to enjoy freedom of expression online, the role of online platforms and so on. International criminal law is also catching up to the realities of how cyber conduct can contribute or even constitute atrocity crimes. Tomorrow, for those who will be here, there will be another session discussing the initiative of the International Criminal Court's Office of the Prosecutor to establish a policy on how cyber-enabled crimes might fall under the scope of the Rome Statute. Of course, there's also well-known the Tallinn Manual, Oxford Statement. So there are a lot of initiatives recognizing that it is important for international law to remain relevant, that we also understand how it applies in cyberspace. And certain questions, I would say, are anyway controversial questions under international law, and they also manifest in cyberspace. One example being for the extraterritorial application of human rights, information operations by a certain state, whether they target the home population or the population in a foreign country. Does that shape the obligations that they have? Does it mean that there could be a protection gap when it comes to the rights holders that might be impacted by certain operations? So what I would say is that those initiatives are very relevant, but I think there could be more effort probably to avoid the fragmentation of the responses to how international law applies to cyberspace, and to make it more, to harmonize it more, to avoid a protection gap. For example, coming back to a potential, say, disinformation campaign that is inciting and dehumanizing and targets people in another country. Potentially, you could have the prohibition of propaganda for war that applies under Article 20 of the ICCPR, or the prohibition of hate speech under Article 20, Paragraph 2 of the ICCPR. Certain of those operations could also be prohibited under international humanitarian law. For example, the obligation to respect international humanitarian law. It could potentially be a violation of the prohibition of direct and public incitement to genocide. So we have all these different frameworks that have something to say about this type of content, this type of state conduct, if that's what we want to focus on. But how they interrelate is not always so established. And from the perspective of the impacted communities and the rights holders who might be harmed by those types of information operations, it is not that relevant whether it's humanitarian law or human rights law and which one is lex specialis. And those can make for very interesting legal discussions. But I think it is important that we find a way to, again, operationalize it, clarify it and make clear what each actor's obligations are and what, again, the rights of the impacted communities really are with respect to all these legal frameworks.
Thank you so much. No, sorry, you have to. Yeah, I think you point out very important issues and very important. One of the most concerning issues about the fragmentations of law is indeed, for example, when we talk about incitement of hate, violence, or propaganda of war. It is there in almost every sections of the law, every forms. I mean, in ICL, in IHL, as well as under the human rights framework. But it has been discussed or interpreted separately. Like international human rights law, we talk about robust plan of actions in which we try to interpret, these sections, but haven't taken into consideration IHL or ICL at all. So yeah, and I want to link it to our next speaker, Tasia, because you have been working in the context in which three of these laws has been collide, has been interact, including on the issue that Chantal gave an example as well, the propaganda of war, incitement of hate or violence. I understand that at the end of last year, Hamlet also have just published a report about digital rights, genocide, and big tech accountability in Gaza as well, in which you also record that there's a race in online hate speech and dehumanization targeting Palestinians. So probably you can explain about this a little bit, and probably you can provide your first-hand observation on how these laws operate in practice, and if you see the gaps when it comes to like a fragmentation of the law in practice, especially in the context of Gaza. The floor is yours.
Thank you so much. Non-state actors, including big tech companies, have obligations under international frameworks such as the UN Guiding Principles on Business and Human Rights to respect and protect digital and human rights. These principles mandate that businesses must conduct due diligence to identify, prevent, mitigate, and account for how they address their impacts on human rights. The right to access the internet, freedom of expression, freedom of opinion, and privacy are all essential for individuals to share their experiences, seek justice, and advocate for their rights. Violations of these rights during such critical times, such as what's happening in the Gaza Strip right now, not only silence marginalized voices, but also hinder efforts to address and prevent atrocities. So in the context of the war on Gaza, the protection of digital rights is paramount. Tech companies and online platforms play a real critical role in documenting human rights abuses, sharing information, and mobilizing support as well. Systematic censorship and discriminatory content moderation policies by these platforms, as seen in the suppression of Palestinian voices, undermine these digital rights. And the disproportionate over-moderation leads to restrictions limiting the reach of Palestinian content at the international level. In some cases, it can completely suspend users. Palestinians and international news outlets, as well as journalists, have all experienced content takedowns and account restrictions on Instagram and Facebook specifically. Another contributing factor to censorship is obviously government requests for content takedowns on social media platforms, which complicates the issue of transparency and bias in content moderation. The United Nations Committee on the Elimination of Racial Discrimination already expressed serious concern about the sharp increase in racist hate speech and dehumanization directed at Palestinians since October 7th, particularly on the internet and in social media. And the ICG order on the plausibility of genocide highlights the gravity of the situation, as they are considering, in this case, the documented use of online platforms to incite genocide against Palestinians in Gaza, including by the highest levels of the Israeli leadership. Hence, all companies providing technology, telecommunication, or social media services in Israel and Palestine need to prioritize a comprehensive approach that really mainstreams and safeguards human rights and addresses the root causes of discrimination against the community and narratives in full transparency and in line with the United Nations guiding principles on business and human rights. And to finish, because there is an intersection of digital rights and genocide in Gaza, we should highlight the urgent need for robust protections and accountability to ensure that digital spaces remain open and equitable for all. Thank you.
Thank you so much, Tasia. Yeah. In the context of Gaza, there's I think you already list out. I mean, there's a lot of study, also statement made by Special Rapporteur, UN mechanisms and others on the use of platform, to commit some prohibited act that may amount to crime under international law, which is including genocide and also the protection gaps as well, which is now not there yet. So we touched upon another red line because it's in the situation of Gaza now, it's not just about protection, but there's an issue about accountability as well. If you talk about the possibility of crime under international law to be committed in that. So I would like to move to the next speaker to touch upon the issue of accountability when it comes to the human rights violation or abuse that committed in the digital space, including those that may amount to crime under international law. So probably, Neves, you can talk about, like the accountability framework as well and challenge in accessing to justice and remedies for those who were victims of human rights violation or abuse that committed online, and probably those who have to face challenge through fragmented legal framework as well. First, yes.
Thank you. Well, this is a quite impressive room. Yes, I mean, building on what my colleagues here have been talking about, I would like to talk about the growing gap in the accountability, and as a consequence, of course, the growing gap on victims' access to remedies. Although international law has a well-established framework of obligations in relation to access to reparations, access to justice, prevention of impunity, procedural remedies, compensation, rehabilitation, and what includes like taking all possible measures so that violations don't occur again. We see that crimes committed or violations or wrongdoings committed being enabled by digital or cyber technology are treated with a level of exceptionalism. So there is this paradox. While most legal scholars think that international law has most of the principles that would help us to provide remedies or to provide a regulation, there is certain exceptionalism on producing new legislation and attempting to create new laws that take time to create, but at the same time create a danger of fragmentation of the law. So, from my point of view, there are 2 or 3 things that appear as but there are more, but I want to talk only about 2 or 3 things in these 5 minutes that appear as a barrier, no? And one of them is this idea of the fragmentation of the law, the idea that specialists in environmental law, specialists on IHL, on ISL, on cyber law, seem to be operating separately and not coordinated, not knowing what the other specialty are doing. And then that creates a situation where it creates lack of certainty. It enables forum shopping, where different actors seek for the most favorable regulation for their conduct. And it creates also difficulties for cooperation, and ultimately the result is avenues for impunity. The human rights system is a coherent system where all human rights are interrelated, we say. But there has been an attempt to try to analyze right by right, which, from my point of view, there is no right that is not affected by digital and cyber and new technologies as we advance in a quite fast pace. Finally, the issue of the close relationship between a state and corporations has created a blurred reality in which it is difficult to know or to define what the levels of responsibility that different actors have in a given situation. A number of situations have also cast a question when international crimes have been committed with the help or with the assistance of cyber or digital technologies. There are some scholars that are starting to call for the international criminal responsibility of companies as well. And there are a number of initiatives on whether it would be possible to expand the ICC Rome Treaty to include also legal personalities. Eventually, for us, there are two ideas that I would like to put forward. One is, do we have all the tools in international law that we require? Eventually, law is not, by definition, is a reaction to social changes, and human rights are the safeguards that we put for every turn of the advancement of societies. And the second question that I would like to put to you is that in the middle of all this information overload, whether or not international law and the content of human rights have been also a victim or have been also been targeted by misinformation campaigns, relativizing international law and questioning their usefulness, creating spaces where there is some gaps of accountability and gaps of regulation eventually. No, I want to stop there so that we can have time for an interaction.
Thank you so much, Neves. Yeah, I think you put on a very important point of the fact that now there's still a blurred line between state and corporate when it comes to who shall be held accountable for certain actions. And it seems like the current international law framework still not catch up to that challenge, but there's still an ongoing effort to address them. So move next to Francisco, who probably could fill in the gaps of the corporate accountability side as well. So Francisco, under international law, corporate required to conduct due diligence. They have due diligence obligations, and they also expect to having a strength. They expect to be held accountable as well when there's a certain kind of conduct that committed on their platform, for example. But in reality, most of the time, we haven't seen a lot of example where the platform will be held accountable when there's a suspect of involvement in certain kind of actions. So probably you can shed light on these issues, like what's the status of international law now when it comes to platform accountability. And also at the same time, because under international law, whatever we do, we have to avoid disproportionate restriction on human rights of the online user as well. So how can we strike the balance between those accountability and protection of the right? And probably you can give example of the recent rulings in Brazil on this issue as well. The floor is yours.
Thank you. I hope you're all listening to me. Hello from São Paulo. I'm wanting to be with all of you guys in Norway. I'm happy that my colleagues laid the ground first in terms of international law and these discussions. Just a disclosure, I'm not the executive director of Internet Lab anymore. Now I am a law professor and an expert consultant of the BTEC project within the Office of the High Commissioner for Human Rights at the United Nations. So in these 5 minutes, I will deal with 3 questions. The first one is, it seems when we entered this, and as our moderator was questioning me, that we have some tensions within the international human rights law. We have prohibition, number of different discourses of incitement, for example, but also protections for freedom of expression and the need to strike a balance. And we also have tools like the United Nations Guiding Principles on Business and Human Rights. So the first question is how to see this. There are tensions, these are layers. I think that it is interesting to see how the United Nations Guiding Principles on Human Rights can act as a more operative layer on that. And maybe a good way to depart this discussion is the assertion that the inaction can produce violations, but also action can produce violations. Also, the statement that corporate can participate on violations and corporate power, and also state actor can participate on violations. And this makes us difficult for navigating, but I think that the guiding principles can provide us at least a more toolbox of different approaches on how we see corporate responsibility. So the second question is, can we turn corporate responsibility into platform accountability? I think this is the main challenge when we see the United Nations Guiding Principles on Human Rights. What will make this is to not only assert that principles and human rights law are valid. I think this is very important, but also we should, as the guiding principles show us, we need to build method to that. And thinking about what means human right due diligence as not any form of due diligence, but a specific one that we need to embolden method. We need to embolden transparency, and we need to raise the bar. And to that, I would like to mention the resources that the BTEC project has. BTEC project is a project within the Office of the High Commissioner that is trying to make this translation. So what does it mean to take all of the principles and human rights that are in different documents and in different tools for international human rights law, and how we can build method to bring companies to this kind of compliance, right? So in terms of AI, for example, we have a different set of tools that we need to apply to that, that combine not only transparency tools, but also building expertise on red teaming, for example, that need to build expertise on content regulation, for example, and that put us in a position that we need to not only point out to methods, but also to think on ways to monitor how they are being deployed and what are the results that we are having during time. And to end my first contribution here, landing this discussion in context, it's very difficult. So in Brazil, for example, we are seeing the judiciary trying to build a platform accountability field. It's important to say that as a Brazilian, I would like to share this. We have a judiciary with a many number of peculiarities that can be very proactive, but kind of this judiciary is trying to play an important role after an attempted coup, and also after challenges from the tech sector leadership defying the rule of law. And on that, we are seeing on how much is difficult to build this field and to build an idea of platform accountability and even human rights due diligence without, for example, state capacities or without a regulator. But of course, we are, as I'm saying on the beginning of my contribution here, not only inaction can produce violations, but action can produce violations as well. So making those steps are very difficult. And I just want to share one thing to make us think on how much the discussion about incitement is very important, as my colleagues were commenting before me. We have an interesting episode, the blocking of the platform X in Brazil. And we saw how much this was spoken about in the international stage, and how much disinformation was told to be the key motive for the Supreme Court to block this this platform in Brazil. And this is not true. Like the core case that made the Supreme Court made that was an incitement case against a law enforcement officer. So advancing on kind of this translation, it's really, really important for not only setting up standards for different contexts, but also on grounding on this context, the capacity that we need to prevent violations, not only from the state power, but also violations that can be facilitated by the private sector. So I'll leave it here, and I'm anxious to hear all of you in our interactions.
Thank you so much, Francisco. So we have the last panelist with us, and indeed that's one of the topics in which we haven't yet fully covered during our intervention today, which is on the disproportionate impact of online harm on specific groups, especially children whose life has increasingly shaped by the digital environment. So Miko, under international law, it's clear there's clear recognition of the children's rights online. However, are there any specific obligations that impose on the state and corporate itself, when it comes to protection of children in the online space? So probably you can share with us about those applications, and and probably you share how the protection of this group could be strengthened as well. The floor is yours.
Thank you very much. So in the 5 minutes I'd like to bring in the perspective of child rights. And so there are many other group of persons who need special attention, but in my case, children. So in 2017, UNICEF report said, worldwide, 1 in 3 internet users is a child. So it's such a reality we learned in 2017. And when I joined in the Committee on the Rights of the Child, actually 2017, we started learning more and more how the digital environment is important to children. So what we learned, the reality is that digital is really part of children's daily lives. Of course, still there is a digital divide. However, children are living with the digital, and children's rights are impacted. I have to emphasize positively and negatively. We very often emphasize the negative impact of the digital on the children's rights. However, children's rights are also promoted or enhanced by digital. So this is a reality. So in 2019, the Committee on the Rights of the Child decided that we need to work on the children's rights and digital relation. Convention on the Rights of the Child adopted by General Assembly in 1989. So we were convinced by the reality that Convention on the Rights of the Child need to be led understood, applied, and implemented in relation to the digital environment, because this is the life the children are nowadays are living. So we cannot ignore this reality, and we have to show how the Convention on the Rights of the Child is relevant to the children's rights. But I also want to emphasize something which I learned through the process of the committee's work to develop this general comment on children's rights in relation to digital environment. It took 2 years in drafting, because we had a wider public consultation, including the consultation with the children. So what I'm going to share with you, what I learned from the children. So children living in digital world space, however, online and offline is seamless. It's not so easy to differentiate what is the online and offline for the children. And secondly, almost all the children's rights under the conventions are impacted by the children. Of course, the freedom of expression and of privacy. However, also many other things like right to play, education, health. In particular these days, mental health is such a serious issue for the children's rights in relation to the digital. And also how to develop the relationship, personal relationship with others, starting from the children's and parents' relationship. And so all those things are actually impacted by the children's rights. And also I have to emphasize the important role of the parents. So if we talk about a lot of privacy, for example, but if the parents are not aware how they are actually imposing the children to the risk online, so the children's rights are not protected. So those are what I learned. But what is most important message from the children are they want to use the digital. So they claim to us, the committee, that they don't want to be totally protected or excluded from the digital space, but they want to use the online space safely. So this is a very strong message from the children. So what the committee said in this general comment adopted in 2021 after the 2-year consultation, I'd like to bring up 3 issues. So one, the committee said that the states and the business should integrate child rights impact assessment. And particularly, I'd like to emphasize one thing. So the committee said privacy and safety in relation to the design, engineering, development, operation, distribution, and marketing of their products and services is very, very important to protect the children's safety and privacy in digital world. Second, what I want to share today is that it's very important to understand the children's rights comprehensively if we want to address the children's rights in digital space. In particular, children are all the persons under 18 years old. So you can imagine how the digital space will impact in the younger age of the children or adolescents. So the evolving capacities is a very important concept. Thirdly, remedies. So for the children, what does that mean to access to justice and remedies on the online harm? So we need to integrate those perspectives, and to do that, we need to hear from the children, their lens and their experiences, what they think, how to protect themselves is a very key. Thank you very much.
Yeah, thank you so much, Mikiko. Indeed, next, I would like to invite all participants to ask questions and share perspective. I know that after 5 speakers, most of what we share were challenges, which due to the fragmentation of international law and especially in terms of providing protections to individual communities and also on accountabilities. Of course, there's still gaps, but yeah, there's still an effort globally to address them. So yeah, I mean, if anyone would like to share, would like to ask any questions, yeah, please.
Hello, my name is Ulvia. I'm from the London Story. We recently published a report which is called Escalate, where we describe how during the India-Pakistan tensions and military conflict in April-May 2025, platforms like X and Meta, they amplified violent and hateful content, while the Indian government pushed for takedowns of critical voices like journalists and human rights defenders. So around 8,000 accounts have been taken down, which verbalized alternative narratives. And for us, this raises a serious issue when states use the content moderation to silence dissent, but don't stop harmful content that can fuel the violence. And in this situation, population is left more vulnerable online, especially during the conflict. So my question would be, when it's the state itself contributing to the erosion of online civic space, who is responsible for protecting civilians in these digital spaces? And how should international law respond to these double standards where both the states and the platform fail to act in the public interest? So I would like just to hear your perspective on this, because we also work on this issue. Thank you so much.
So,
Okay, please. Are you taking questions in turn? Are you going to take questions in
I
turn?
think we probably can take one more questions and then we answer.
Yeah,
this
sounds
in time.
good. Yeah, I think my question kind of relates to what was just mentioned about kind of the role of the state. We've heard from the panel the idea of international law placing kind of duties and responsibilities in terms of due diligence on corporations, and I think this is kind of the language or the ideas that we are seeing increasingly more also in domestic legislation, so platform regulation that also kind of requires companies to have some kind of due diligence, assess risk mitigation, risk identification, or kind of duty of care if adopt, for example, the UK Online Safety Act embodies this concept. And then my question is, how do you see the two of them fitting together or not? Is kind of international law and this kind of domestic efforts to hold platforms to account friends or foes? How can we make them friends and foes? Because you also hear from some voices, and I think some of the previous comments was in that direction, that states can also violate international human rights law, right? So how can regulation kind of both international and domestic kind of be driving change and accountability in the same direction and not be kind of conflicting? Yeah, that's my question.
Thank you so much. Robbie, I think we take the first round, probably 4 questions.
4 is a bit too much. No? Okay.
My audio device isn't working as well, so I'm not sure if I'm being heard right now. Okay, great. Hi, I'm Anna Galate. I represent UC Berkeley. I work as a public interest cybersecurity researcher and practitioner, and I have background in software development, psychology, philosophy, so on and so forth. I want to say thank you, first of all, for this overview of international law and its application. But during our time here, the focus largely appears to be how current international law, human rights, criminal, could be applied or amended to better intersect with rights needing to be protected within the digital spheres, but the nuances are far more complex given how intertwined and interdisciplinary our digital selves journey truly is. You know, complex domains such as political infrastructure, behavioral psychology, economic power, tech design, these are all purposely interwoven to converse within like a digital user's daily rhythms. My question, are there any efforts underway for separate legislation for our digital selves, you know, one that is far more holistic to protect, for example, like cognition and mind and our thoughts? Like, there are new technology deployed day by day at an exponential rate that is attempting to scrape and source by any means possible to better build our digital profile and kind of use us as a pawn. So just wondering if there are any efforts, like separate efforts, given all that. Thank you.
Can I proceed?
Yes, please.
Okay, thank you. My name is Christian Fazili. I'm from the Democratic Republic of Congo, and I work as a lecturer and a researcher at the University of Goma. I'm also a civil magistrate. Thank you for the wonderful presentation. I have a few questions related to this topic. Beyond voluntary commitment, what binding framework could ensure equitable digital governance, such as a global treaty on tech accountability? Another one related to due diligence. To what extent are states obligated to prevent malicious cyber activity organizing from their territory? And the last one, how can this be enforced without infringing sovereignty? Thank you very much.
Thank you so much for all the questions. I think we have the questions that on when the state itself contribute to online erosions, who gonna protect civilians and respond to double standard. Probably who want to respond, Chantal? You want to respond to the first questions? And we can give the second question to Francisco as well, and probably you want to answer the third question. Okay, probably you the first question first.
Let me perhaps make sort of overarching observations on I think a number of the questions. I think one of the challenges is that we see we see that there are massive challenges as to the conduct in the digital space. There are digital harms, new digital harms, technologies evolving fast. How can we keep up, right? And we know that those advancements are often much quicker than the ability of certainly international bodies, but of domestic parliaments as well to come up with good rules. So I think one of the problems that we have right now is perhaps I don't think we're exactly in the golden age of treaty making. So that also means that we will often try to rely on existing international law rules and see how can we operate with them, how can we interpret them for them to remain relevant, because it seems reasonably unlikely that there will be a new Geneva Convention adopted, ratified, and widely implemented anytime soon, I think. The second challenge is also, I think, I understand the quest for wanting to regulate some of these issues, but I think the devil is in the detail, and also following up on what Francisco said and what other panelists said, it's a very complex space. And again, as has been mentioned, inaction can be problematic and action can also be problematic. So what sort of rules, there has been a question about a global treaty on the digital accountability, I think, or again, lawmaking to address some of these technologies. It's just some of the legislations we see are very reactive, not based on human rights. So you have this disconnect between the international law obligations of states, particularly human rights obligations, and what they do domestically. They don't bring the domestic legislation in line with human rights. They also don't do it based on proper expertise, so it's not necessarily good lawmaking. Again, you might have to bring a psychologist in. You want to hear from children's rights groups when you regulate those issues. So I think it's sometimes, again, the response can be almost as problematic as the lack of response. Perhaps also one point on the role of online platforms also that we've seen in armed conflicts, India, Pakistan. I think one of the things also to mention, and I think Nieves has mentioned this as well, often platforms also operate or respond to government demands as well. So it's not, it's not states do one thing and platforms do another. More and more, depending on the governments, depending on the power of the governments, there is very close cooperation and engages both states' obligations and companies' obligations. And I think there is also a big responsibility for us to understand whether the right measures has been taken. I'll wrap up. The devil is in the details with these measures, be it, as Francisco mentioned, a blocking of X in Brazil or an arrest of the Telegram CEO in Paris. We need to have really the details, understand why exactly it has been done. There needs to be transparency as to the real reason, so we can also really scrutinize and assess whether those measures are in line with international law. I try to sort of connect a few thoughts.
Can I? Yeah. There are a couple of interesting points. I mean, the issue of state actors' behavior in platforms is one that needs to be addressed. And I'm not sure, I agree with Chantal, I'm not sure it's the golden age of new legislation. I mean...
It's not.
It's not.
No.
That's what I said. Yeah, that I agree. Yeah.
Okay.
No, it's not the golden age of, because we have seen at international level, but also at national level, we have a couple of projects where we try to compare national legislation with international obligations. And every single time that we face this reaction of legislating more, and every time that we get it, then it's more repressive kind of legislation. So that's one thing. The other thing is that there are the legislation in relation to incitement. So in relation to justification of war, to justification of crimes, is all. We have examples of that. We have the media trial, but before that, Nuremberg, so the concepts of law might exist. The way we implement them and the willingness for enforcing them is where I feel that we are lacking behind. I want to address the issue that I think the second question brought up on the issue of how technology is advancing so much that there are some. What a friend of mine, Suan Teo, wrote about is the issue of freedom of thought now takes a different connotation because technology actually might advance to that point that what you think can be reachable even if you don't announce it. As technology will advance and we will have to take decisions on whether the legislation that we have covers. But what I would warn against is whether we do have a real vacuum or what we have is unwillingness to enforce international obligations that exist. Yeah, I think I'll leave it there.
Yeah, probably also on the second question, Francisco, you want to help answer as well on domestic registration on platform regulations. And also probably you can help answer on the beyond voluntary commitment. Are there any buying frameworks, especially on tech and due diligence as well?
Yeah, I'll make some comments. Are you all listening?
Yes.
Yes.
We are listening.
Great. So the question is if platform regulation for accountability and international human rights law, if they're friends or foes. I think they can be both, depending on the situation. Actually, like as Chantal was saying, action and inaction are both pervasive. If you're seeing what's happening. And then there's no recipe for this. But maybe a few points should be made. First, with or without legislation, with or without some kind of regulatory framework, I believe that human rights due diligence coming and looking to the United Nations guiding principles on business and human rights, they can be fruitful in terms of at least laying the ground for some kind of intervention that can help us to know more what's happening, helping us to know more what is working or not, and helping us evolve on which is the right way to intervene or to demand corporate responsibility in a very concrete way. But I know that all of that there are baby steps, right? It's not something that you can sketch up from one day to another. And also, all of that should happen with involving stakeholder engagement, involving participation, involving transparency tools for civil society. This is the kind of part of a human rights due diligence process that can also ensure that everyone is participating and everyone is in the same page. But also with legislation, when we are seeing regulatory frameworks, I think it's also key on monitoring how this legislation is performing. So seeing out what are the checks and balances for state action and state power, and thinking about that there is no end line. There is intervention and testing, and more intervention and testing. And some things can go wrong. And we need to acknowledge that some things can go wrong. Some innovations of legislation can go wrong as well. And I don't see this as a way of paralysis. I see this as a way of learning what's working or not. And to end, remedies are also key. Right, not only remedies around corporate power and corporate on corporate decisions, but also remedies on state decisions. And to really end, just a question here, and I would love to exchange more on that. We're talking a lot about sovereignty and how important for ensuring corporate responsibility this can be as well. But I think an important question should be made, like sovereignty, it can be a path for many things, right? Rule of law can be a path for many things. And I think we as human rights defenders and people that believe on human rights, international law as well, we should see sovereignty and rule of law in all of these complexities and to understand what are the ways that can serve as a path for protection also of human rights. So, but this is more of a question than an answer. And I thank you for it.
Thank you so much, Francisco. Probably last question. I think we're running off time. Probably the last one I asked Mikiko then, because there's questions about judging from the existing floor that we are talking about today, are there any effort on separate legislations that try to holistically address the issues, especially when technology day by day has been like with the threat of technology day by day? Probably you can talk about it from the children's rights perspective as well, and probably you can update a little bit on the effort that we are engaging or involving in.
Thank you so much. So I heard, so the first question for the panel, we started talking about the international law means international criminal law, international human rights law, international humanitarian law. And then I brought in the child rights perspective. And as I emphasized that the children is not only the one group which requires the specific attention. And I heard from Nevers talking about the risk of fragmentation. So how can we holistically approach all those issues? I don't want to mean by sharing the children's perspective to again going into the silo or fragmented approach. So I think we really need to bring in various perspectives and diverse voices when we talk about how this big question, international law, applies and should play a role in the digital space. So there is no answer. However, the consultation process and hearing from various voices, not only about the groups, but also regionally, because there is a lot of different initiatives and challenges. So it's not so much answer. However, I think this is the way we should go. Thank you.
Thank you so much. I think it's already time's up. So thank you for all of your time, and I hope today's sessions was helpful for you. I think it's just the beginning of talking more of this topic, and we hope to engage more with all of you and this topic in the coming years as well. Thank you so much.